I'm telling you, we have Mr. Corey Beckles, and we took 4 minutes of his time, and he's getting it back, I tell you. But let me bring him right in the studio. Welcome back. We hope you had a great anniversary, wedding anniversary celebrations.
Yes, thank you. It was good. It was good.
It was 13 years.
Yes, 13. Yes, 13.
13 years. Well, congratulations again. And of
Thank
course,
you.
we missed you, but you were taking care of family, and that's very important. Well, over to you, sir.
Right. Yes. So we are talking about paternity issues in estate matters. Um, I also have a PowerPoint. Yes, thank you for bringing up the PowerPoint. Paternity issues in estate matters, and now this is a very important issue. And paternity usually refers to proving. So paternity issues refer to proving that some man, is your father. So this is where the child has to prove that this gentleman is their father. Or you also have circumstances where the father is proving or has to prove that the child or that individual is their child. Now, that second circumstance can occur where a child is set to inherit an estate. And from our previous lessons, our previous programs, we would have learned that parents can also inherit a child's estate once the circumstances are
Yes.
once the circumstances are present. A parent or parents can inherit. So there may be situations where the father has to prove that that child, or he is actually the father of that child. So now we go in now to some other issues concerning paternity. So we are looking now at births. Births. Why paternity? Why paternity?
Mm-hmm.
Why paternity? So there are many children in the Caribbean. Many children in the Caribbean who are born and their father's name is not on their birth certificate. The mother's name is there, of course, but the father's name is not there on that birth certificate. Now, there are also many fathers, many men who father children, who the children are living with them, but their names are still not on the birth certificate. And the birth certificate is the only proof of paternity. Well, there's other proofs of paternity, which is DNA. But as relates to the birth certificate itself, the birth certificate is not only the proof of birth, but it is also the proof of paternity. It is one of the documents that the court will use to determine whether or not someone is the father of an individual. And if the father's name is not there, then you also have to go to an attorney at law, and you have to apply to the court to be
Mm.
declared the father of that individual. So let's go to the next slide, Marcia. So paternity can affect your ability to inherit through a last will and testament. So in previous programs, we've been talking about persons dying testate and persons dying intestate. And we're looking now at persons who die testate. They die
Yes.
with last will and testament.
Yes.
And you will find that there are certain wills that have been drafted with these clauses in it. And one such clause is, I give my property, and this is just an example, I give my property situate at Lancaster to all my children. And all my children is a general term. And when you have general terms in wills, there is the
Mm.
possibility, there is the risk of a misinterpretation. And we also have the risk of persons being excluded. That is why it's very important when you're drafting wills to be as specific as possible. So when you have this term in a will that says all my children, only those persons that can prove that they are the children of the testator will be able to inherit under that clause in the will.
Ah. So
Because
let
the
me ask you
testator,
something. If they had put the names of the children there, that could work?
yes, that would suffice to be able to show who are the children.
I
So
see.
even if, and that's a very important question, even if one of those names, and you look at their birth certificate, and the father's name is not on the birth certificate, they will still be able to inherit because their specific name was referred to by the
Yes.
testator in the will. But when you have a general clause that only refers to children, then you now have to go and look and see who are the legitimate children. Not just because I also want persons to understand the legitimate and illegitimate. That difference and definitions, those are no longer part of the law. So
Mm.
children born out of wedlock are still children in the eyes of the law here in Barbados. But when I say illegitimate, I'm talking about persons whose father's name may not be on their birth certificate. So they now have to prove, unless there is some specific name mentioned in the will, they will have to prove that that individual was indeed their father. But to answer your question, as long as you have the specific name of your child or your children inside of the will, that will suffice.
Yes.
That will suffice for them to be able to inherit. We also have another example where a will says, I give my property situated at Diamond Corner to all my grandchildren. Again, all my grandchildren is a general term. And the children of the testator's male children will now have to prove paternity to be able to inherit their grandfather's estate. And this is important because sometimes we have estates where it is the great grandparent, the
Hmm.
grandparent who has mentioned this, all my grandchildren in the will, and you now have to determine who are all of the grandchildren. And a grandchild who cannot trace their lineage through the necessary documentation may have the possibility of being excluded from inheriting that estate.
Wow.
So it
Mm.
delays matters, Marcia. And you don't have to go and pay more money. You have to go and get advice from an
Right.
attorney to see what you're going to do in this circumstance.
You
Because
know
some,
what? One of the things that every time you come on is about us being specific in the will.
yes, yeah, I can't
Specific.
mention that too much. You have to be when you're drafting your will, when you are referring to your assets, when you're referring to your beneficiaries, make sure that you are able to identify. Make sure that anyone reading that will be able to identify your assets and identify your beneficiaries with certainty. If
Yes.
you can put where your beneficiaries currently reside, if you can give information as where they resided at some point in time so that they can be found, all that information is very important when you are
Mm,
drafting
mm.
wills.
So in a case like this, where a grandparent might want to say, "Well, I don't want to leave out any a grandchild that might be born after I am
Correct.
gone." So then probably that's why they would say all my grandchildren.
Correct.
But then it can create, more legal fees and more. It might be more costly because you have to prove.
Correct. Yeah.
Mm,
And you also have situations where you may have, yes, those grandchildren who are easily identified. They
mhm.
can trace their lineage through their birth certificates and there's no issue. They may have a problem with a child or a grandchild who may not have that proof. They may not have that direct proof of them. They may challenge that grandchild and basically tell the court, well, I don't believe that person is my family. I don't believe that they're family to my grandmother or my grandfather, the case may be, and they will
Mhm.
challenge their ability to inherit through the court system. And
Yes, yeah.
yeah, and that is very, very important.
Somebody here is saying that they prefer the DNA test and the birth certificate to determine one's paternity.
All right. Yes. So when you go into some more specific issues in paternity, and you have situations where yes, someone's name is on the birth certificate as the father, but then you need a DNA test. The DNA test, sorry, will determine with even more specificity that this individual is either the father or not the father. So a
Mm-hmm.
biological test is very important in situations where paternity is an issue. You may not necessarily find in estate matters that persons rely on DNA tests. Normally, a person, when they are have any sort of issue, paternity issue in estate matters,
Mm-hmm.
sometimes the mother is still alive, and the mother can sign an affidavit verifying that she was in a relationship with that gentleman at the birth. When that child was born, they were in a relationship of some permanence. They were living together. They were in an intimate relationship. And the mother now is able now to tell the court, this was the situation when our child was born. And this is the reason why his name was not on the birth certificate.
Yes.
Then this will be evidence before the court. But then we have some estate matters where the mom is no longer with us. And then you may now have to rely on the evidence of a brother,
Mm-hmm.
uncle, an aunt, and you're basically at their mercy. Because if they don't give you the evidence,
Right.
then you are in trouble. You are in trouble. So that is why it is best not to put your children, if you want your children to inherit, and you know that but your name is not on their birth certificate, it is best to nip these things in the bud when you are drafting your will. Make sure you name them specifically. And if you go to the next slide.
Yeah. Very, very important.
All right. So I spoke a little bit about this just now. So proving paternity is much easier when the father is alive. And if the father is alive, then he can sign an affidavit verifying that he is the father and apply to have his name added to the child's birth certificate. Now, the unfortunate thing here, Marcy, is that paternity issues in estate matters usually only arise after the death of
Yes.
the loved one, because it is only at that time that persons recognize the need
Mm-hmm.
to resolve these paternity issues. But it's always best that paternity issues are resolved while everyone is still with us on the earth. That really is the best time. But of course, these things will still arise in estate matters. These issues will always arise in estate matters. And we're coming down the road. So when you decide, so we have given you some practical advice here. When you decide to make a will, ensure that you name all your children specifically, and do not use general terms such as all my children. Now, remember, Marcia, you spoke about children that may not be here as yet.
Yes.
Now, so I'm going to ask this question. What happens to an unborn child? You have a child who is still in its mother's womb, and the father dies before the child is born. What happens in that situation? Will the child still be able to inherit if that term, all my children, is used? Well,
Mm-hmm.
it's really a rhetorical question because I'm going to answer it too also. So the answer to that question is yes. If the will refers to all my children is interpreted to mean unborn children, children still in the womb. The
Uh-huh.
child must be in the womb and the child must be born. So everything must go well with the birth and the child comes into this world. As long as that occurs, the child will be able to inherit under that clause, all my children. But all my children does not refer to a child that really is not in contemplation whatsoever. The child must be in the mother's womb to be able to come under that general term of all my children. And that is important because that unborn child is vulnerable, not just vulnerable physically, but as relates to their legal rights. It is very important that the courts recognize and acknowledge their legal rights to the estate of their father. Remember, the father has died, so there's no way for the father's name to be on the birth certificate. And this is where DNA may come into play to prove beyond a reasonable doubt, beyond any other possibility, that this child belongs to the deceased gentleman. Right, so that's just important. That's a very important point.
Somebody,
So,
somebody is saying, but I think this is answered already. If somebody, the child was not from that father, but the father was tricked in believing that that was his child.
right, yeah,
The DNA and all of that would take care of that, right?
yeah, DNA will take care of that. Now, if remember DNA, you can only take DNA from, yes, you can take DNA, should be able to take DNA from a body that is not alive, but it becomes more difficult when the gentleman or the father has been deceased for quite a while. If there's any challenge to the fact that that child was never really his, then you still need to provide the evidence that will overturn. Because if that gentleman's name is listed as a father in the birth certificate, then you have a document that proves paternity. And to be
Right.
able to overturn that document, you need evidence, you need substantial evidence, something that is substantial enough to overthrow what is written in the birth certificate. And yes, DNA will be able to do that. You
Yeah.
may be able, and I'm just thinking about the situation, you may be able to get DNA from the fathers or from the gentleman's family members. That may be able to help, but it will still be it's a long shot, Marcia, to be able to prove these things, especially when a lot of time has
So
passed.
try to do it before.
Yeah.
Somebody saying here, business finance is asking, do these paternity issues require that notices be published in the press?
Yes, if you are applying for gentleman, any gentleman, to be declared in law to be your father, even if this
Yes.
gentleman is deceased, then you will have to publish the notice in the newspaper that you have made this application to the court,
Oh,
so
wow.
that there's any individuals who see the notice and they want to challenge your application, they're free to do so. But you must
Oh,
let the entire world know that you are making this application.
oh,
And this
wow.
is the application for a declaration that this gentleman is or was your father when he died.
When he
Right?
died. So you can put that in the newspaper.
Yes.
Somebody is saying here, I think I'm not the lawyer, but I think I know the answer to this from what you've been saying. The other classes, I have two children and I don't plan on leaving a will. Should I leave a will for both of them or it doesn't matter?
Right. So should I leave a will for both of them? Well, I always go on the side of having a will and making sure their names are in the will. I don't want to make sure that I'm answering the question and I understand the question. Right? So I always, even though there's no issues as it relates to who is your children, there is no issue whatsoever, no paternity issues, nothing at all. I still prefer to have a will. I still prefer.
I think they're saying, you know what, if I have two children and I have two houses, well, I told Pam this is yours and I told John this is yours.
Yeah,
And
yeah, that is fine, but I still prefer.
mhm.
I still prefer that you make a will, and even if the only way that you shouldn't make a will is if you're going to give these assets to your children while they are still alive. While you're still alive. So if you are going to do a deed of gift,
Deed
you
of
are
gift,
going to
yes.
transfer these assets to the children. You can even
Mm-hmm.
transfer the assets to the children and yourself, so that when you die, it automatically goes to the named child, to the survivor. So, but if you are leaving it, if you're not transferring it throughout your lifetime, I still prefer to have wills done.
Mm-hmm. Yeah, or do it. Yeah, yeah. In your. I boy, I know all these terms now. A deed of gift.
Yes, yes, very
Wonderful,
important.
wonderful. Guys, any other questions? Please put them in the comment section. We have literally 8 more minutes to go. Go ahead, Attorney
Right, yes.
Beckles.
Right. So to be safe, ensure that your name is on your children's birth certificates, just to be safe. So
Mm-hmm.
when you're doing your estate planning, yes, you acknowledge them as your children, but it's still good to ensure that all of your children's names, well, your name, sorry, is on your children's birth certificate. So there is no issue whatsoever for them if an unfortunate event occurs.
Occurs. Let me ask you something. Somebody's asking, why does the world have to know? Why do you need to declare this to the world in the, in the
Right,
press,
the application.
the application?
Right. So because there will be, or there is the possibility that someone will challenge the
Mm.
application, because you're asking the court to do something, to make a very important decision. Now remember, this gentleman is no longer with us. He's
Yes.
deceased. And you're asking the court to declare that this gentleman who is not here to give evidence, you're asking the court to declare that he is your father. And not only that, you're asking the court to place his name on your birth certificate as your father. So
Mm-hmm.
it's a very important claim that you're making, and it's a very important request that you're making from the court. So the court must ensure that the entire process is fair. So this is not a process that should be done in secret. It is not a process that should be done pulling the wool over anybody's eyes. Everybody should be able to know that you are making this application. And if there's anyone who has an interest in the application, anyone who may disagree,
Yes.
I see the comment here, maybe contested. If there's anyone that wants to contest that application, they should get full opportunity to do so. And that is why you have to advertise that you are making this application to the court. Because the law is in trying to ensure that the process is fair,
Mm-hmm.
and that everybody, even if no one responds, at least we have evidence that you advertise in a daily newspaper in Barbados. And there is a possibility that persons would have seen it and said, well, I'm not bothering with contesting that. But there has to
Mm-hmm.
be evidence that you invited others, allowed others to know that you're making this application to the court.
Yeah. Someone is asking, is there a way to bypass taking out letters of administration?
Well, there is a way to bypass that, or the only way really to bypass taking out letters of administration is if the assets were given during the lifetime of the deceased,
Mm-hmm.
or if there is a trust in place. So there's really very limited ways to bypass, or limited circumstances in which
Mm-hmm.
you can bypass taking out letters of administration. As long as that deceased individual had assets that were not distributed prior to their death, it's only in limited circumstances, Marcia, that you'll be able
Mm-hmm.
to bypass letters of administration. We have
Yeah.
situations, just quickly, like a vehicle. Now, the only way to sell the vehicle of that deceased individual is if you, well, not the only way, but the legal way, the usual way that you would normally sell that vehicle is first obtaining letters of administration to the estate, and then using that letters of administration to sell the vehicle. That is the usual way, or the proper way that it should be
Mm-hmm.
done.
Yeah.
Now, there are individuals who may not have known that you needed letters of administration, or the individuals who were in possession of the vehicle prior to the death of their
Yeah.
loved ones, and they may have sold the vehicle, right? The law is not going to be too hard and fast on you, but it is always good that you do things the right way,
Yes.
right?
Yes.
And the right way is normally getting letters of administration.
Letters of administration. Someone is saying here, I need to get my dad's name changed on my birth certificate. It is correct for my siblings, but he also used another name which is on mine. So it's correct for on the siblings, but on their
Right,
birth
yes, yes.
certificate,
I
it's
understand.
another name.
Right, which is just it could be a clerical error.
Hmm.
In fact, in Barbados, this is a
They
common,
want to know what is the process.
yeah, this is a common process. This is a common error. Now, is dad still alive? If dad is still alive, it is a very easy change. Dad can just inform the registry, and they will start the process from there to get his name or his correct name placed on the birth certificate. Now,
Oh, he's deceased, the person said.
right. So, if he's deceased and you are applying for letters of administration or even probate, there is a document called an affidavit of one and the same. Because in Barbados, in the Caribbean, we're, we are individuals who are known by many different names.
Yes, nicknames.
We have one name on our Barbados identification card or your Trinidadian identification card. You have another name on your birth certificate. You have another name on your NIS card. You are known by another name on the Electoral and Boundaries Commission. So your name is different all over. And so in those situations where the person may be deceased and you still have to conduct business on behalf of their estate, you will file something called an affidavit of one and the same. And this affidavit is basically saying that this gentleman who is named in this particular way
Mm-hmm.
and this other name that is different, maybe spelled differently, maybe even a totally different name, but still the same last name, you are basically telling the court that these three names all refer to the same individual. These three names all refer to the same individual, and you
Yeah.
provide the evidence. You'll provide the national identification card, you'll provide the birth certificate, you'll provide even the marriage certificate, because there are persons' names who are different on their marriage certificate. But you will show that all of these names refer to the same person, and that will suffice. So
Mm-hmm.
it is not something that will prevent, if you are applying for letters of administration, different names is not going to prevent you from obtaining your letters of administration, but you still have to verify or confirm to
Mm-hmm.
the registry that these names all refer to the same individual.
Mm-hmm. Mm-hmm. Mm-hmm.
Yes,
Wow.
state your full name and say in the comment there, state your full name. In fact, which is also a very important point before I know that the time is running out, Marcia. Very
Yeah.
important point. When you are doing your will, you can say, well, I, Corey Beckles, also known as Corey Beckles, and Corey could be spelled differently, Corey, but it is best to put almost all of your names. Put as many names as you are known by in your
Mm-hmm.
will.
That's interesting. That's
Many,
good.
yeah,
That's a good advice there. That's good.
yeah,
Wow. All the different names you put in
yes.
there.
Anything that
Just
you can think of, even a nickname,
yes.
put it in
Wow.
your will so that there is no issues as relates to identifying who um who this name belongs to.
Mm-hmm.
Yeah.
That's what it would is to be clear, specific.
Yes, I can. If that is the theme of of my presentation every
Mm-hmm.
Monday, it will be specific. Be specific.
And get a will. Don't leave it. Don't leave it to chance. Don't leave it for them to figure it out. Put it in a will.
Yes, I always prefer a will. If you do not want a will, then I would advise you or your attorney would advise you, well, go a different route.
Deed of gift. See, I
Yes,
got
deed
that.
a gift, deed a gift, or a
Listen,
trust.
or what?
But
Or put them in a
trust,
trust.
put it in a trust,
Yes, I
right? But
remember that.
if you're not going to do those two things, then I still prefer having a will. Even if it's
Yeah.
simple, even if your life is simple and your estate is simple, I still prefer wills.
Yes, yes. Well, Colert is saying thank you. He said it was so educational. He's the one that was asking that specific question. Really appreciate your presentations. And well, because we have to end now, because these things I love Monday nights, you know. I got all these notes in my book here. I want to say to anybody who is watching, if you still have questions, just reach out to me and I can provide you with Attorney Beckles' number. That's okay, Attorney
Yeah, that
Beckles.
is fine. That is fine.
I can provide you with his number so you can ask any questions that you have. Okay. Yeah, and so that you can be educated in any final word before we go to Mr. Alwyn Bab.
Right. Yes. So very quickly, when you are planning your estate, remember paternity issues.
Mhm.
If you know that there is the possibility that paternity issues will arise, then make sure you let your attorney know. Make sure you advise him or her of the issue, and I'm certain that your attorney will be able to let you know what you should do in those circumstances.
Well, thank you so much. Thank you. Each week, I mean, when we think that, oh my goodness, you learn so much. Each week you've added, you come and you add another layer. And I think the PowerPoint is great. I love it. Because it's helping us to understand. I appreciate the time that you've taken to put it all together. Thank you so
Yeah.
much, Attorney Beckles,
Thank
and
you
wishing
also.
you all the best in your practice.
Yes, thanks for listening. Have a good evening.
Fantastic. Thank you.
All right, bye.